London and Nordic marine insurance market. A comparative analysis in relation to marine insurance cover. London is recognized as the worldwide leader for the marine insurance market. The development began in the 18th century when by means of the Bubble Act it was forbidden to corporations and societies to run the marine insurance business unless they were authorized by Act of the Parliament or Royal Charter. This measure created a virtual monopoly for two companies. Anyway, there was no provision in the law that prohibited individuals to carry on this business. The opportunity was taken by entrepreneurs at the old coffee house of Edward Lloyd. Lloyd was created as the marine insurance location by individuals and it became recognized as the place for obtaining marine insurance. In the early 19th century, Lloyd of London was already the dominant marine insurance market worldwide. Individual underwriters use forms to specify coverage and exclusion in the contract of marine insurance. On 1779, Lloyd issued the SG form of policy, which was later included in the Marine Insurance Act 1905 as the first schedule which could be used as standard. The institute clauses began to appear in the 19th century. They took this name because they were promoted by the Institute of London Underwriters ILU along with Lloyd's. Since the creation of the institute clauses, they were updated in order to maintain competitiveness in the insurance market, to clarify concept and also as a response to case law. In the 80s, a new set of standard clauses were developed. The tradition of the London market was and continues today to insure vessels against specific named perils. Three types of hull clauses are available in the London market. The Institute Hull Clauses ITZ, Voyage and Time, edition 1983 and 1995, and the International Hull Clauses HIC, edition 2003. The application of the clauses isn't compulsory and they are now published in the IUA Clauses Document Library website. IUA is the International Underwriting Association of London, an entity that superseded the ILU due to a merger with the London International Insurance and Reinsurance Market Association, LIRMA. The Nordic Association of Marine Insurers, (SEBR), initially promoted by Norwegian companies, which previous name was the Central Union of Marine Underwriters, is the current leading organization for the development of standard rules in the Nordic marine insurance market. The first Norwegian standard insurance condition, known as the Norwegian Marine Insurance Plan, appeared in 1871 with the auspices of Det Norsk Veritas DNV. It is known that for all the plan but the first have been developed under agreement basis with the market participant. On 2001, DNV transferred his intellectual property right regarding the plan to SEBR. The plan had its last version on 2010. Further, SEBR promoted the enactment of the Nordic Plan. On 2010, the Ship Owners Association of Denmark, Finland, Norway, and Sweden signed an agreement with SEBR in order to develop a Nordic marine insurance plan. The plan was approved and available on 2013, and the result was the Nordic Marine Insurance Plan of 2013 based on the Norwegian Marine Insurance Plan of 1996, version 2010. According to the agreement, the plan is to be updated every 3 years, therefore the 2016 version is available. The clauses are also not compulsory. The difference with the London market is that the Nordic plan is the result of a formal agreement by ship owners and the insurers. The plan is considered to be unique as compared with other non-Nordic market conditions. The main difference with the London market is that the Nordic plan states as standard the all-risk principle. Once a loss is justified, it is the insurer who has the burden of proof that an exception should apply. The all-risk principle is at the heart of the plan. Insurance implication. As an example, if a vessel enters in a collision with a ferry and makes contact with a berth ram and the incident generates damage to the colliding vessel's hull, her cargo and the collided vessel as well the ram, there will be different consideration for the owners of the vessel and the owners of the cargo in both London and Nordic markets. Loss or damage to the colliding vessel. If the colliding vessel is insured in the London market on the Standard Institute hull clauses or the international hull clauses, the partial loss sustained by the vessel is covered in consideration that a collision is a peril of the sea. Basically, collision is to be considered as a contact with another ship. It is noted that the vessel also hit the berth ram, and the damage to the hull of the vessel may come from this particular incident. According to English law, this is not to be considered as a collision due that this is not a contact with another ship, but the loss is covered according to standard hull clauses and the international hull clauses as contact with land conveyance, dock or harbor equipment or installation. Therefore, every loss to the vessel insured which is consequent of a collision or contact with a dock installation is covered. But the insurer will verify specific warranties and its compliance, and the compliance of condition for any health-covered clauses included in the policy. The insurer in the London market will also verify causation to determine the proximate cause of the loss, which according to English law is the near inefficiency and not in time. If the causa proxima deals with willful misconduct of the insured, then it is most likely that there will be no recovery. If the incident is a result of a bursting of boiler's breakage of shaft or any latent defect in the machinery or hull, negligence of repairers or charterers provided such repairers or charterers are not insured. Barratry of master officers or crew, then the Is clause takes effect and the loss will be recovered. The 50% of the cost of repairing or replacement of such boilers or latent defect are covered under the international hull clauses, but an optional clause named additional perils is included with a cover of 100% of such costs. In the case of the conditions set in the Nordic plan, the all-risk principle operates. Clause 2 until 8 of the current version of the Nordic plan state that an insurance against marine perils covers all perils to which the interest may be exposed. The clause determines some exceptions to this rule which are related to war perils, intervention of a state power, insolvency, and perils related to the Race 2 clause, which consists of nuclear and radioactive matters not used for peaceful activities.